Well, I just read through the Court of Appeals decision in the Michael Flynn case, and I've got to tell you, I would not want to be Judge Gleeson right now. I would not want to be Judge Sullivan.
And I sure as heck would not want to be Judge Wilkins.
Viva Frei, Montreal litigator turned YouTuber, and I have limited time to do this vlog because I'm going fishing with the kids today, but I'm getting this vlog out today, heck or high water. The Court of Appeal just issued their judgment on Michael Flynn's petition for writ of mandamus enjoining the Court of Appeals to order Sullivan to dismiss the charges as per the Department of Justice's motion to dismiss.
Try to say that 10 times in a row.
The Court of Appeal issued their decision, and although it was a split decision 2-1, they granted Michael Flynn's petition for writ of mandamus, and they ordered Sullivan to dismiss the charges against Michael Flynn. Now, I'm not doing a summary, I'm not doing a 30,000-foot overview. I am taking for granted that if you're watching this vlog, you have a sufficient understanding of what has been going on in the Michael Flynn judicial saga. But if you don't, I'm going to link a playlist on the Michael Flynn judicial saga right here. Give those a watch if, for whatever the reason, you haven't already seen those
masterpieces of judicial breakdowns.
The Court of Appeal decision was a split decision along party lines, and we'll get into that in a second, but to say that this is a victory for Michael Flynn would be the understatement of the judicial year. I've said it before and I'll say it again, this should not be a partisan issue, this should be a justice issue, and it finally seems that justice has been served. In a nutshell, the Court of Appeal concluded that Judge Sullivan had no basis for refusing the Department of Justice's motion to dismiss the criminal information against Michael Flynn, and that he usurped the role of the executive in appointing his own amicus to pursue those charges. I know that is complicated, but if you've been watching my vlogs for long enough, you should have a sufficient understanding of what that all means, but let's just go ahead and see what the media is reporting on this judgment. The WFAA reports, Appeals Court orders dismissal of Michael Flynn's criminal case. The decision was made even though Flynn pleaded guilty to lying to prosecutors in Special Counsel Robert Mueller's Russia investigation. And I've got to say, if that is your headline and caption, you either didn't read the proceedings, you didn't understand the judgment, or you are trying to spin and not inform. According to Vox, the court decision dismissing charges against Michael Flynn is astonishingly bad. Naomi Rayo rides again. Alright, that is about enough of the mainstream media's opinion and spin. Let's get into the judgment itself. Now, the case was heard before a panel of 3 appeal judges: Robert L. Wilkins, Karen L. Henderson, and Naomi Rayo. If I am mispronouncing Naomi Rayo's name, I apologize. I am not doing it on purpose. And because I know some people find it relevant in understanding the split decision, let's just go through those judges one by one. Robert L. Wilkins was appointed by Barack Obama. Karen L. Henderson was appointed by George H.W. Bush. And Naomi Jehangir Rayo was appointed by
Donald Trump.
At the very least, that might help understand the particularly unflattering headline as relates to Judge Rayo. Judge Rayo and Henderson were the majority, Rayo filing the decision, and Wilkins was the dissenting opinion. And I've got to say, I don't know who the majority opinion was harder on, Judge Sullivan, Judge Gleeson, or Judge Wilkins. But let's just get right into the judgment itself. United States Court of Appeals for the District of Columbia Circuit argued June 12, 2020, decided June 24, 2020. First and foremost, a summary of the questions before the court. Flynn petitioned for a writ of mandamus before this court pursuant to the All Writs Act, 28 U.S.C. section 1651, seeking 3 forms of relief. 1. An order directing the district court to grant the motion to dismiss. 2. An order vacating the amicus appointment. And 3. An order reassigning the case to a different district judge. For this court to grant a writ of mandamus, quote, the right to relief must be clear and indisputable. There must be no other adequate means to attain relief, and the issuing court, in the exercise of its discretion, must be satisfied that the writ is appropriate under the circumstances, end quote. Applying these standards, we grant Flynn's petition in part. Now, the core question at the root of all of this revolves around the now infamous Rule 48A of the Federal Rules of Criminal Procedure. That rule provides that the dismissal of charges against a defendant requires the leave of the court. The leave of the court is fancy talk for the permission of the court in order to dismiss the charges against the defendant. And the core question at the heart of the Flynn proceedings are, on what basis can the court refuse to grant leave to dismiss the charges when the prosecution decides to drop those charges? Some have argued that when it comes to granting leave under Rule 48A, the court basically has absolute discretion to deny leave, whereas others have argued that the court basically has virtually no discretion and can only deny leave under very exceptional circumstances. I know the conclusion to which I came after doing multiple vlogs on the subject. You know my conclusion as well, but let's see what the Court of Appeal says. Although Rule 48 requires, quote, leave of the court, end quote, before dismissing charges, quote, decisions to dismiss pending criminal charges, no less than decisions to initiate charges and to identify which charges to bring, lie squarely within the ken of prosecutorial discretion, end quote. United States versus Fokker Services. Quote, to that end, the Supreme Court has declined to construe Rule 48A's leave of court requirement to confer any substantial role for courts in the determination whether to dismiss charges, end quote. Bottom line, despite what others have argued, in deciding whether or not to grant leave, the court does not benefit from any substantial role in that decision. And why would this be the case? Well, we're going to get into it a little later in the judgment, but it has to do with the separation of powers between the executive, legislative, and judicial branches of government. The leave of the court required under Rule 48A was never intended to grant to the judicial branch the power to override the executive in its prosecutorial discretion. More simply put, the rule is that judges judge, prosecutors prosecute, and judges do not prosecute. Whatever the precise scope of Rule 48's quote, leave of court, end quote, requirement, this is plainly not the rare case where further judicial inquiry is warranted. To begin with, Flynn agrees with the government's motion to dismiss, and there has been no allegation that the motion reflects prosecutorial harassment. Additionally, the government's motion includes an extensive discussion of newly discovered evidence casting Flynn's guilt into doubt. Specifically, the government points to evidence that the FBI interview at which Flynn allegedly made false statements was, quote, untethered to and unjustified by the FBI's counterintelligence investigation into Mr. Flynn, end quote. In light of this evidence, the government maintains it cannot, quote, prove either the relevant false statements or the materiality beyond a reasonable doubt, end quote. This is something we've discussed in previous vlogs as relates to the Rule 48A, and we're going to get back into it a little later in this vlog, I think, but Rule 48A was implemented to ensure that there was no prosecutorial harassment of a defendant. The rule was intended to apply to situations of harassment, corruption, bribery, situations where the Department of Justice did not motivate its decision to drop the charges. Absolutely none of these circumstances apply to Michael Flynn's situation. He consents to the Department of Justice's motion to drop the charges. And the DOJ's decision to drop the charges, far from being capricious or arbitrary, is thoroughly justified in their motion in light of the newly discovered evidence. The court then goes into a brief discussion of the concept of presumption of regularity. The government's representations about the insufficiency of the evidence are entitled to a, quote, presumption of regularity in the absence of clear evidence to the contrary. On the record before the district court, there is no clear evidence contrary to the government's representations. Then the court addresses a commonly repeated argument that only the prosecutor signed off on the motion and no other line prosecutors, as though that somehow undermines the motion itself. The justifications the district court offers in support of further inquiry, for instance, that only the U.S. attorney signed the motion without any line prosecutors and that the motion is longer than most Rule 48A motions, are insufficient to rebut the presumption of regularity to which the government is entitled. And think about that reasoning for a second. Leave of the court can be denied under Rule 48A when there is insufficient justification for dropping the charges, yet the district court was also arguing that it can be denied where the motion under a Rule 48A is abnormally long. Damned if you do, damned if you don't, or as others might say, arguing from conclusions as opposed to towards them. Then we get back to the law and the separation of powers, and the court writes as follows. These clearly established legal principles and the executive's, quote, long settled primacy over charging decisions, end quote, Fokker servers, foreclose the district court's proposed scrutiny of the government's motion to dismiss the Flynn prosecution. Before this court, the district judge explains that he plans to question the bona fides of the government's motion, inquire about the government's motions and representations, illuminate the full circumstances surrounding the proposed dismissal, and probe whether the presumption of regularity for prosecutorial decisions is overcome in the unusual facts of this case. A hearing may sometimes be appropriate before granting leave of court under Rule 48. However, a hearing cannot be used as an occasion to superintend the prosecutor's charging decisions because, quote, authority over criminal charging decisions resides fundamentally with the executive without the involvement of and without oversight power in the judiciary, end quote, Fokker servers. The district court's orders appointing an amicus and scheduling the proposed hearing therefore constitute clear legal error.
Ouch.
There is the argument that legal errors can be corrected on appeal. Sullivan hadn't decided anything that could not be corrected on appeal, therefore there was no irreparable harm that could warrant the issuance of a mandamus. To which the court responds as follows. In this case, the district court's actions will result in specific harms to the exercise of the executive branch's exclusive prosecutorial power. The contemplated proceedings would likely require the executive to reveal the internal deliberative process behind its exercise of prosecutorial discretion, interfering with the Article 2 charging authority. Thus, the district court's appointment of the amicus and demonstrated intent to scrutinize the reasoning and motives of the Department of Justice constitute irreparable harms that cannot be remedied on appeal. And this is an interesting argument that I had not thought of before. Forget Flynn, set Flynn aside. The irreparable harm is to the system itself, not to Flynn as an individual. The irreparable harm is in Judge Sullivan thinking he gets to exercise oversight over the executive branch, over prosecutorial decisions. Talk about acting as judge, jury, and executioner all at once. And just in case Sullivan wasn't hating this judgment enough already, it gets even worse. The first troubling indication of the district court's mistaken understanding of its role in ruling on an unopposed Rule 48A motion was the appointment of John Gleeson to, quote, present arguments in opposition to the government's motion, end quote. Whatever the extent of the district court's narrow role under Rule 48A, see Fokker servers, that role does not include designating an advocate to defend Flynn's continued prosecution. The district court's order put two, quote, co-equal branches of the government on a collision course, end quote. And here we see it again. The irreparable harm has less to do with Flynn as an individual and has to do with the system and the integrity of the system itself. And it still manages to get worse for Sullivan. The district court chose an amicus who had publicly advocated for a full adversarial process. Based on the record before us, the contemplated hearing could require the government to defend its charging decision on two fronts, answering the district court's inquiries as well as combating Gleason's arguments. Moreover, the district court's invitation to members of the general public to appear as amici suggests anything but a circumscribed review. This sort of broadside inquiry would rewrite Rule 48A's narrow, quote, leave of court, end quote, provision. And we need not guess if this irregular and searching scrutiny will continue. It already has. On May 15, Gleason moved for permission to file a brief addressing, among other things, quote, any additional factual development he may need before finalizing his argument, end quote, and suggesting a briefing and argument schedule. It is not a partisan statement to say that this is clearly a case of the judicial branch overriding and usurping the power of the executive. These actions foretell not only that the scrutiny will continue, but that it may intensify. Among other things, the government may be required to justify its charging decisions not only in this case, but also in the past or pending cases cited in Gleason's brief. Moreover, Gleason encouraged the district court to scrutinize the government's view of the strength of its case, a core aspect of the executive's charging authority. Because this is not the unusual case where a more searching inquiry is justified, and because there is no adequate remedy for the intrusion on the, quote, executive's long-settled primacy over charging decisions, end quote, we grant the petition for mandamus in part and order the district court to grant the government's Rule 48 a motion to dismiss the charges against Flynn. Now, for those of you who watched my previous vlogs on the subject, you may know that I predicted that the Court of Appeal would send this back down to Sullivan to make the right decision, but it looks like they were sufficiently irritated with Sullivan that they made the decision for him. And incidentally, if you've watched any of my live streams on the subject with Robert Barnes, I do believe that Robert Barnes got it right to a T. And although the Court of Appeal granted the petition for writ of mandamus, they denied the request for reassignment to a different judge, which seems somewhat academic given the fact that the charges are going to be dropped now. We deny Flynn's petition to the extent he seeks reassignment of the district judge. This case does not meet the, quote, high bar, end quote, for reassignment, which would be appropriate only if the district judge's conduct was, quote, so extreme as to display clear inability to render fair judgment, end quote. And I've got to say here, I kind of disagree with the Court of Appeal in that if Sullivan's conduct does not display a clear inability to render a fair judgment, I don't know what does. Sullivan has proven himself to be so clearly unable to render a fair judgment that the Court of Appeal had to do it for him. How much more evidence do they need? But whatever, I guess they're trying to allow Sullivan to save at least some face in the context of this scathing decision. Flynn focuses primarily on comments the district judge made at sentencing, but, quote, judicial remarks during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties, or their cases ordinarily do not support a bias or partiality challenge, end quote. In light of these precedents, the district judge's conduct did not indicate a clear inability to decide this case fairly. We decline to reassign the case to a new judge simply to grant the government's Rule 48A motion to dismiss. And there you have it, the Court of Appeal basically saying, look, we've embarrassed Sullivan enough. We don't need to reassign this case to another judge just to issue the dismissal under Rule 48A. We are going to order Sullivan himself to do it. You know, come to think of it, that might actually be even more embarrassing. And after hammering Sullivan and to a lesser degree Gleason, the court then goes on to hammer the dissenting opinion, Wilkins. Now, I'm not specifically going to go over Wilkins' dissent in this video because I think the majority does a good job responding to the issues raised in Wilkins' dissent, so let's just go ahead and do that to finish this up. We include the following responses to the dissenting opinion in order to clarify the extent to which the dissent's arguments are foreclosed by long-standing precedent and fundamental separation of powers principles.
Ouch.
First, the dissent glosses over the presumption of regularity to which the executive is entitled in the exercise of its prosecutorial discretion. While the district court is not a, quote, rubber stamp, end quote, when considering whether to grant leave of court under Rule 48, any judicial inquiry is strictly bounded by the presumption of regularity, and the presumption is overcome only in extraordinary cases and by, quote, clear evidence to the contrary, end quote, Armstrong. The dissent fundamentally misstates our opinion by insisting we hold, quote, a district court may not even consider a Rule 48 motion before giving its leave. Perhaps that is to distract from the simple fact that neither the dissent nor the district judge has identified a legitimate basis to rebut the presumption here. Simply put, there was simply no evidence to justify rebutting the presumption of regularity from which the Department of Justice benefits. But wait, there's more, and actually a lot more. Second, the dissent undermines our recent decision in Fokker Services by recasting its necessary and well-considered reasoning as dicta. In that case, we relied on, quote, settled constitutional understandings, end quote, to determine that Rule 48A's leave of court requirement, quote, confers no new power in the courts to scrutinize and countermand the prosecution's exercise of its traditional authority over charging and enforcement decisions, end quote. Third, the dissent asserts our adherence to Fokker Services creates a circuit split. Yet if a split exists, a proposition we dispute, it would be a result of Fokker Services' binding interpretation of Rule 48A. The level of scrutiny, quote, left open, end quote, by Rule 48A must be understood in light of the respective constitutional constitutional powers assigned to the judiciary and the executive, which suggests a natural limit on the appropriate judicial inquiry. All right, I'm going to blast through these last points because I just received a clear indication that the wife and kids are ready to hit the road. Fourth, although our dissenting colleague apparently agrees there is no need to cite a case on all fours before granting mandamus relief, he faults the majority for failing to identify a case in which mandamus was granted in nearly identical circumstances. Arguably very superficial reasoning. Show me a case exactly like this case to justify what you want to do in this case, failing which we don't get to do it. Dissenting opinion in Fokker Services, however, directly rejects such a requirement. Quote, "We have never required the existence of a prior opinion addressing the precise factual circumstances or statutory provision at issue in order to find clear error justifying mandamus relief." Checkmate, Wilkins. Fifth, the dissent minimizes the import of the district court's orders claiming that we are granting mandamus, quote, before the district court has acted, end quote. This is something I specifically mentioned in previous vlogs. People are going to say, oh, the district court didn't decide anything. He just ordered an amicus to present a brief. He has not yet rendered a decision on the Department of Justice's motion to dismiss. To which I responded, he has in fact decided a lot. He's added additional delays. He's added a burden on Flynn as a defendant. He has decided a lot in fact and in law. But what do I know? I am just a Canuck talking at you through my camera in my car on the streets of Montreal. Let's see what the Court of Appeal has to say about that. Yet the district court has acted here. It has ordered briefing and scheduled a hearing in order to provide a court-appointed amicus the opportunity, quote, to present arguments in opposition to the government's motion to dismiss, end quote. Although no decision has yet been made on the motion to dismiss, the district court's judicial supervision, quote, threatens to chill law enforcement by subjecting the prosecutor's motives and decision-making to outside inquiry, end quote. Sixth, the dissent maintains that mandamus must focus exclusively on the petitioner's harms, not the government's, because the government has not formally petitioned for mandamus. Our court has squarely rejected this argument. In Cobell, we granted mandamus on the basis of irreparable injury to the executive branch in the absence of a, quote, separate petition for mandamus, end quote, filed by the government. Again, the harm is not just to Flynn as an individual, the harm is to the system itself, and the Court of Appeal is righting that wrong in this judgment. And it seems like the Court of Appeal left the best for last. Seventh, the dissent swings for the fences and misses by analogizing a Rule 48A motion to dismiss with a selective prosecution claim. Of course, the executive may not, quote, selectively prosecute someone based on impermissible considerations, end quote. But, quote, the equal protection remedy is to dismiss the prosecution, not to compel the executive to bring another prosecution, end quote. Yet unwarranted judicial scrutiny of a prosecutor's motion to dismiss places the court in an entirely different position. Rather than allow the executive branch to dismiss a problematic prosecution, the court assumes the role of inquisitor, prolonging a prosecution deemed illegal by the executive. And just to wrap it all up nicely, the court concludes as follows. Ultimately, the dissent fails to justify the district court's unprecedented intrusions on individual liberty and the executive's charging authority. This is not a case about whether, quote, a district judge may even hold a hearing on a Rule 48A motion, end quote. Rather, it is about whether, after the government has explained why a prosecution is no longer in the public interest, the district judge may prolong the prosecution by appointing an amicus, encouraging public participation, and probing the government's motives. On that, both the Constitution and cases are clear.
He may not.
For the foregoing reasons, we grant Flynn's petition for a writ of mandamus in part and direct the district court to grant the government's Rule 48A motion to dismiss. In light of that grant, we vacate the district court's order appointing an amicus as moot. So ordered. And there you have it. Unless something radical happens and this moves even higher up the judicial hierarchy, Flynn is a free man. And I dare say, after the hours and hours of research and vlogging on the subject, I didn't do all that bad with my prediction. Good enough at the very least to give myself a pat on the back and go fishing. And that's what I'm about to do today. As always, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, or share my channel with someone who you think might appreciate it. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, PayPal, Patreon, Subscribe Star, YouTube memberships where everybody gets sneak peeks at my videos in as much as I can offer sneak peeks. But more important than any of that, take care of yourselves, check in on friends and family, go outside, get some fresh air, enjoy life, and now you know your vlog. Peace out. Booyah!